Good afternoon, ladies and gentlemen, dear Dean of the Law Faculty, dear professors, students from the Erasmus program, and the Aristotle University of Thessaloniki and the University of Macedonia. It is a great pleasure to be the president of this panel in a conference organized by the two Jean Monnet chairs, the one from Aristotle University, where in charge is Associate Professor Mrs. Lina Papadopoulou, and the other one from the University of Macedonia, with Assistant Professor Anagnostopoulou in charge, as well as with the postgraduate course of Aristotle University. New dimensions of equality and discrimination law is the topic of our discussion today, and we are very happy to have a guest professor, a keynote speaker, Professor Gráinne de Búrca, coming all the way from New York. Before we start, I would like to ask the Dean of the Law Faculty, Professor Septemvriou, to take the floor.
Ας το πούμε και στα ελληνικά και στα αγγλικά. Συγχαρητήρια στις δύο κυρίες του... Το σκεφτόμουν για τον Jean Monnet, για τις δύο έδρες Jean Monnet που κάναν τόσο μεγάλη... και τρεις κυρίες του συγκριτικού δικαίου για τις τόσο ωραίες εκδηλώσεις που μας κάνουν, που τιμούν και φυσικά για την νομική μας σχολή. Dear ladies and gentlemen, it gives me great pleasure to extend you all a very warm welcome on behalf of the Dean of Faculty of Law of Thessaloniki, and it's a great honor to have Professor de Búrca with us today, best specialist in European constitutional law, and I wish you every success in your deliberations. Εδώ σταματάει και ο δικός μου ρόλος. Σας εύχομαι καλή συνέχεια στις εργασίες σας με πολύ επικοδημητικό διάλογο. Ευχαριστώ πάρα πολύ. Γεια σας.
Thank you, Professor Septemvriou. Now, Associate Professor Mrs. Lina Papadopoulou is going to present the curriculum vitae of our keynote speaker, Professor de Búrca.
Thank you very much, Ms. Chairwoman. I'm really very pleased to welcome here Professor Gráinne de Búrca from the New York University. As a matter of fact, now she comes from Spain, where she spends a sabbatical. She's the keynote speaker for the evening, and there will be some interventions for some scholars from our universities, Aristotle and Macedonia. But let me first introduce Professor de Búrca. As already said, she's a professor at the Law School of the New York University, and she's a world-leading expert in European Union law, European human rights law, and European transnational governance. Before giving the floor to her, some words a little bit more extensive. I think it's worth knowing her a little bit more in depth. She was born and raised in Ireland. She undertook her undergraduate legal studies at the University College Dublin, and she then obtained an LLM at the University Michigan in the United States. And then she returned back to her home country, to Ireland, for 2 years, where she trained for the bar at King's in Dublin. In the 1990s, she was a lecturer in law at the Oxford University and fellow and tutor in law at Somerville College in Oxford, where she also served as a deputy director of Oxford University Centre for European and Comparative Law. Then, until 2005, she was a professor of law, the youngest and actually one of the first female law professors in the prestigious European University Institute in Florence, where she also held the position of the co-director of the Academy of European Law. In 2006, she moved to the United States, so she changes the continent. There, she taught at Fordham Law School before joining in 2010 the Harvard Law School faculty with tenured post as professor of law. During the same period, she has also been a visiting professor at Columbia Law School, a member of New York University's Global Law faculty, and Strauss Inaugural Fellow at New York University Law School. Since 2011, she has been the Florence Ellinwood Professor of Law at New York University, School of Law again, while currently she also holds the position of the Director of the Jean Monnet Center for International Regional Economic Law and Justice, and of the Faculty Director of New York University's unique Hauser Global Law School. Gráinne de Búrca's impressive academic and employment record is accompanied by an equally amazing scholarly production, both quantitatively and qualitatively. She has written or edited 11 books, I think, maybe more, and more than 70 articles, book chapters, reviews, notes, and comments, and she co-edits the very well-known Oxford Studies in European Law book series. She also serves on the editorial board of the European Law Journal and the Journal of Common Market Studies, and on the advisory board of numerous other journals. Her profile as transatlantic, okay, because she moves between the both sides of the Atlantic Ocean, legal scholar, and her personal trajectory have to a considerable degree shaped her research agenda. Her initial love was legal and political theory and philosophy, and it is not incidental that she concentrated in her LLM thesis at Michigan Law School in legal theory. However, her first move from Ireland to the UK, when she became one of the youngest fellows ever appointed to Oxford University, was quite a change for her research plans, even though both countries belong to the common law family. More specifically, in the United Kingdom of the late 80s, she found herself in a legal system where nobody seemed to teach or study European Union law. And yet, there was an increasing sense that law students needed to learn European Union law. When she started teaching European Union law there, she very quickly discovered a very interesting dynamic in the UK, where there is a very strong attachment to parliamentary sovereignty, as you may know, and therefore different kinds of tensions with membership of the European Union. Then she realized that all the questions that she had been interested in as a young promising legal theorist were situated in a new context, not the national one, but now the European, the transnational one. Gráinne de Búrca's scholarship of her, let's say, Oxford decade, when she was at the Oxford University, equally covers core constitutional topics of European Union law and also of UK public law, and especially its membership to the European Union. Furthermore, during the same period, she started her long-term and close cooperation with Professor Paul Craig, a very famous professor as well. As the author team of the Oxford University Press leading textbook, I'm sure you have seen it, at least, if not already read it, EU Law, Text, Cases and Materials, which is something like the Bible of the European Union law. And as a matter of fact, we know that she's now preparing the 6th edition of this book, and we have this little detail because a graduate student of ours used to be also a student of Professor Gráinne de Búrca. This is Mr. Dimitris Nikiforos, and as a matter of fact, we owe to him also the visit of Professor de Búrca here in Thessaloniki with us. In the early 2000s, Gráinne de Búrca moved to Florence. Very beautiful academic environment, I would say, completely different intellectually from what she had already experienced, very cosmopolitan, transnational, multilingual, and multicultural. As a result, her view on European Union law and scholarship changed again. In a period when the obsession with the EU primacy and constitutionalism was beginning to be tested and challenged, she started working on research projects which were focused on the move from uniformity to flexibility and on issues of law and governance. Thus, her scholarship of, let's say, the years in Florence reflects this interdisciplinary perspective beyond the strictly legal perception of EU law. During the same period, she was also a member of the working group of the Robert Schuman Center at the University Institute, the European University Institute in Florence. And this institute was actually commissioned by the European Union Commission to write a report on the reorganizing of the European treaties. Not only did this report serve as a feasibility study for what became the European Union Constitutional Treaty afterwards, and of course its successor, the Lisbon Treaty, which is now in force, as you know, but it also gave her the inspiration to write some of the most influential studies on the drafting process of the European Union Constitutional Treaty. But Florence did not gain her forever. She returned back to the United States at Fordham, Columbia, Harvard, and then New York University Law School. And then again, this change, this move, marked a new phase of her scholarly thinking. Teaching European Union law to non-European students in the US was quite different from teaching the subject in law schools within the European Union, where law students, so you, all of us, take it for granted that we have to study European Union law because it is our law. In the United States, this is not something that should be taken for granted. In this US era of Professor de Búrca, she argued on a lot of cases concerning a lot of matters that were adjudicated by the European Court of Justice of the European Union, the ECJ, or Court of Justice of the European Union nowadays. We still know it as ECJ, as a matter of fact. And there, she actually she argued that a specific decision that fueled a lot of writing, the well-known Caddy decision, that this decision actually revealed an increasingly reserved and even skeptical approach to international law by the side of the Court of Justice of the European Union. The thesis of that study has been further reinforced in light of the findings of her most recent article. As far as I know, maybe you have written something else which I don't know yet, with the title International Law Before the Courts, the US and the European Union and US compared. The analysis over a 10-year period of the case law of the US Supreme Court and of the Court of Justice of the European Union dealing with international law shows that the approach of the European Court of Justice has changed over time, and today the European Court is as much concerned about the constitutional autonomy of European Union law and of the Court itself as it is about the openness of the European Union system to international legal order. In this sense, Professor de Búrca concludes that it has gradually come closer to the traditional position of the US Supreme Court in protecting US sovereignty. But for the Greeks who are in the room, there is something else other than her brilliance, her productivity, and substantial influence on European Union law that touches us. So what also touches us is her strong attachment to the idea of transnational integration, more general, and of European integration in particular, with the purpose of civilizing interstate relations as a value worth pursuing, despite the ambivalence about the actual manifestations of EU integration. The emphasis on the economic integration the European marketization of life and its negative implications long before the Euro crisis is something we own to her. So for us, in these times of Euro crisis and austerity, it is really important to re-articulate that value of transnational cooperation. Nevertheless, one of the issues that have strongly attracted Professor de Búrca's academic interest from the very beginning until today is the European Union equality and anti-discrimination law. Although over time her perspective, methodology and substance maybe has altered through time, I think what remains is her interest in the social face of the European Union, and of course that she always offers new angles from which she sees and she researches on EU equality law. Therefore, this is also the topic of tonight. We're very delighted to welcome Professor Gráinne de Búrca tonight as a keynote speaker of this conference focused on new dimensions of EU equality and anti-discrimination law, and we're strongly interested in listening to her lecture on a decade of anti-discrimination law before the European Court of Justice, a disappointing retreat or appropriate restraint. Professor, thank you very much for being here, and you have the floor.
Well, first, can I say a very warm thank you to Professor Papadopoulou, not just for this incredibly generous and thoughtful introduction, but also for inviting me here, and also to Professor Anagnostopoulou, and also to Dimitris, who she mentioned, Dimitris Nikophoros, who was my research assistant last year at NYU and has long sung the praises of Thessaloniki to me, of the university here and of the city. So it's a great honor and a pleasure to be here, and I'm very happy to have the opportunity to talk to all of you. It was very nice and interesting to hear that presentation of the trajectory of my work and the interaction of the personal and the political and the intellectual, so I really appreciate that. And I guess my talk tonight touches on elements of all of the different things that have interested me about the EU, the social face of Europe, Europe as more than the market, the little elements of European law over time that have done more than simply integrate marketplaces, but have tried to make it a fairer, a more just marketplace too. And I thought the time would be right recently when I noticed that it had been really 10 years, more than 10 years, since the introduction of the two anti-discrimination directives in 2000, to have a look. I realized when writing the latest edition of my EU textbook that there has been 10 years now of these directives in force, moving EU equality law beyond sex equality. We had decades and decades of EU sex equality law and gender equality law, and we have very extensive analysis of those. But what has happened under the new legislation? What is the picture that we see? Have they made much of a difference? And particularly the question I wanted to ask was, what role has the court played? How has the court used, interpreted, and applied these directives? And why is that an interesting question to ask? Well, it's interesting for many reasons, but one particular reason for focusing on the court rather than just on the equality law in general and what impact it's had in the States is that the court really was seen as being at the vanguard of equality law over the decades. Those of us who are interested in gender equality, sex equality, it used to be just women, but now it's all of us, I think, who are interested in sex equality, know that the court had a very active role in interpreting, enforcing, expanding, giving life to the sex equality directives in the 1970s. So it did a lot over those years. It declared the EU treaty provisions to have horizontal direct effect. Dufresne and Despina, that private parties were bound by the equal pay principle. That was a big, big move back then that got little attention. But also things like an expansive notion of indirect discrimination. Anyone who knows about the United States equality law will know that what they call disparate impact law has struggled in the courts of the US. The courts, and the Supreme Court in particular, does not like the idea of looking to see whether law has disparate impact. In other words, discrimination that's not intentional, but laws that by their effect really impact on a certain group much more than others. So the European Court of Justice developed a strong idea of indirect discrimination. It developed a notion of reversing the burden of proof, where a plaintiff could at least show prima facie discrimination but couldn't prove it, because it's often very difficult to prove. The court insisted on appropriate remedies, all kinds of other elements. So undoubtedly the court was one of the leading proponents, exponents and promoters of EU equality law. And so my question was thinking, well, have we seen much of these new equality directives? What role is the court adopting in relation to the race directive, as it's called, the directive on race discrimination adopted in 2000, and also on the framework equality directive adopted in the same year? Now, why do I say a decade when they were adopted in 2000? Because the time limit for implementing them only expired late in 2003. So there's really been 11 years during which litigation could arise, be sent to the Court of Justice, and the court could respond to these. So what do the two new directives do? Well, the first thing that you may know is that the reason for these two new equality directives, the reason for the expansion of EU equality law, was Article 19 of the treaty, which was introduced by the Amsterdam Treaty. So this was a new frontier for EU anti-discrimination law. It wasn't just about sex equality, equal pay for men and women, which was still very much linked to the marketplace, you know, ensuring equal conditions of competition across states. But now equality law was to be extended so that race discrimination was prohibited as a matter of EU law. And under the Framework Employment Directive, disability discrimination, age discrimination, religious discrimination on the grounds of religion or belief, and sexual orientation discrimination were included. So these two major pieces of legislation expanded the frontiers of equality law. And so now it's not just the court with sex equality, but there's a whole other body of equality law to be enforced and interpreted. And let me just say that when I wrote the title of this paper, when I was asked to, I hadn't yet written the paper, so it was an impression. And my impression was, from the reading I'd done, was that the court isn't really anymore in the vanguard. So that whatever, this moment of expansion of EU equality law hasn't been accompanied by a corresponding expanse or approach of the court to bringing them to life, to ensuring all the same things that it did in relation to sex equality. I wasn't sure if that would be right, so the purpose of this lecture was to look into all of the case law, and I have looked at all of the case law that has come before the European Court in those 11 years on race, disability, age, sexual orientation, and interestingly, there's not a single case on religion or belief. So that's an interesting thing to bracket and come back to at the end. Also, just to mention before I get into looking at the approach of the court is, well, there's a third directive. Okay, so we had this big move, you could say a political move on the EU's part, a legislative move, to adopt new laws mandating equal treatment in these other grounds. But there's another directive. Why? A pending directive. Well, that directive was proposed by the Commission because these two directives were criticised by commentators, by NGOs, by academics, because of the inequalities amongst the grounds of equality. In other words, sex equality still got the strongest protection in the law. Then race discrimination, interestingly, the directive on race discrimination is quite expansive in its scope. It covers housing, education, social security, issues that the directives on gender, sex, and age, disability, and so on do not cover. They are limited largely, not entirely, but largely to the employment sphere. So anti-discrimination or non-discrimination on grounds of disability, age, sexual orientation, and so on, and religion, are limited to the employment context. You have protection as an EU citizen against discrimination on those grounds insofar as it relates to the access to or conditions of employment or benefits related to employment. So why this? So the new proposal then was to equalise the grounds, to try to bring in the same protection for these other grounds as for race and gender. But interestingly, although the directive was proposed in 2008, it has not been adopted. And again, I want to come back to that at the end of the talk to think about whether that's part of the reason for a less vanguard role for the court, a less of a leadership role for the court in the new grounds of equality. There is political hesitation now about expanding further the scope of EU equality law. And the question is, well, is the court going along with that hesitation? What cue is it taking from that political hesitation? Is it ignoring it, as it often did in the past with sex equality, and pushing ahead with an insistence on enforcement of EU equality law, or is it reflecting that hesitation in its rulings? Okay, so not to say too much in detail about the two anti-discrimination directives, but let me just briefly summarize what they do. The Race Directive prohibits direct and indirect discrimination on grounds of racial or ethnic origin. The Framework Employment Directive, the other one, prohibits direct and indirect discrimination on grounds of religion, belief, disability, age, and sexual orientation. They both require the protection of individuals in the field of employment and vocational training, but as I mentioned, the Race Directive goes beyond that to cover education, social security, healthcare, access to and supply of goods and services, including housing. Finally, both directives prohibit harassment, instruction to discriminate, victimisation of complainants, and very importantly, they have a big chapter on remedies and sanctions. And they put a lot of time, and in a way, a third of the directive is spent on provisions dealing with sanctions and remedies for discrimination. They place a lot of emphasis on collective kinds of remedies, and by that I mean a role for NGOs and the social partners in promoting equality, in enforcing the directives, in supporting complainants, bringing actions under the directives. And also they require the establishment of equality bodies that are committed. So these are institutions, national institutions, committed to promoting and enforcing and assisting the spread of equality along these grounds. So that's a very brief synopsis of the two directives. As I said, the time for implementing them expired in 2003. We've had 11 years. What has happened in that time? And in particular, I'm not so much looking at what has happened in the legislative enforcement of directives, but in the judicial enforcement. How has the Court of Justice responded to the cases that have come before it, and how many cases and of what kind have come before it? So what I will do is to run briefly through the various grounds of discrimination, starting with race and the cases that have arisen under the Race Directive, and moving on then to disability, sexual orientation and age, to get an overview of what has happened. And the first thing to notice about the Race Directive is that in 11 years, remarkably few references have been made to the court. Especially, given that you would think it's not that we don't have problems of race discrimination in Europe. Maybe at the time Article 19 was adopted, the member states presented it at the time as being about the new member states that are about to join, the Big Bang enlargement for Central and Eastern Europe, as though these were the states with the problems of race discrimination. But in fact, what you see is that the case law has come from all kinds of states, new and old, as we call them, or former, existing and more recent member states. But so far, I think the number of cases in the field of race has been very low in all. But a trickle of case law has come to the court, and maybe more interestingly even than that is the fact that the court has not wanted to accept all of the cases that came before it. It has rejected one, maybe one of the most important, I would say, of the cases so far to come before it, on a ground I'll explain in a minute. And for others, it said this doesn't amount to ethnic or racial discrimination. Those might have been justifiable rulings, but nonetheless, the court is being careful and limiting the scope of its rulings in this field. So probably the most important case in the field of race is still the first one, the Firma Ferin, where the court ruled that a public statement by an employer who was seeking to recruit workers, that it couldn't employ immigrants because its customers did not want to give immigrants access to their private residences. The court treated that as equivalent to a statement that it would not employ people on grounds of their race. So that was that's quite a progressive judgment in a way. It wasn't looking for the term race or a clear indication that this was racist, but simply to say, well, our customers don't like immigrants in their homes. That amounted to a statement that was potentially racially discriminatory. But since then, the court has rejected 3 other cases. So one called the Servet case involving an Albanian national in Italy. The court made quite clear race discrimination is not nationality discrimination. The directive makes that clear, and the court ruled on that. So the fact that he was rejected for a social security benefit on the grounds of his nationality is entirely compatible with the directive. So that's a case where the court was simply, in a way, enforcing the terms of the directive, which make this sharp, if kind of uncomfortable, distinction between race and nationality. But the case where the court probably eschewed or avoided an important opportunity to rule, I think, is the Bellof case, dealing with the Roma, which came before the court from Bulgaria. And this was a case involving alleged discrimination really kind of across broad swathes of the Roma community by situating electricity meters at a height which they couldn't be reached at. So people couldn't check their electricity consumption, couldn't check their rates, and obviously it was on the basis of suspicion of tampering, that they were suspected, that it was suspected they would tamper with the meters, and therefore they were placed at, unlike in any other district of Sofia where meters could be reached by residents, these in all the Roma districts, all the districts where the Roma were concentrated, where they lived, they were placed at this higher level. The case was brought with the support of an equality body, an NGO, but the court in the end, against the advice of the Advocate General, who ruled that it was admissible and that there was indirect discrimination on grounds of race, the court said, well, we're not convinced that the body making the reference is a court. So it was an equality body that was given different functions. One was a kind of a publicity sort of support function. The other was a separate tribunal function. And it was the tribunal part of the body that had made the reference. According to the Advocate General, it fitted with the terms, the definition of a court or tribunal in the court's previous case law, but the ECJ said no. So I think that's interesting. The court's avoiding giving a ruling there on the Roma, which is probably the big race issue in Europe these days, but that was the approach it took. There's other cases, Runovic-Varden, a case about Lithuanian legislation which wouldn't allow people from the Polish minority to have their official documents in their own language and script, but in the Lithuanian language and script, which required the alteration of their surnames. And the court said, well, you know, this might be various things, but it's not discrimination on the basis of ethnicity, even if this was an ethnic minority or a national minority. So that's another case in which the court rejected ruling. A further case, Agafite, which was slightly obscure, it's hard to tell from the facts, but it said, well, discrimination on the basis of social class, social status is not race discrimination. So that was another that the court didn't rule on. And then it gave a sort of a mildly positive ruling in a case called Meister, where again the race issue is not entirely clear, but the applicant claimed that she was rejected from a job opportunity on the basis of, amongst other things, her race, and the employer wouldn't give her any information about the job, who'd been hired, how many people applied for it, and what the court said was, well, the refusal to give her any information was a factor that could possibly give rise to a presumption that there may have been indirect discrimination, but it could be rebutted by the employer if they were willing to provide the information. So that's a more positive ruling. So in all, that's it for the race litigation. A minuscule output in a way under the directive after 11 years. So that's not, the small output isn't the fault of the court, because the tiny trickle of cases references being made is not something the court has control over, but its reaction to them or its response to them is. And as we see, it's clearly avoiding making rulings on the basis of race in certain cases where it could have done so. Okay, so the second piece of anti-discrimination legislation then is the Framework Employment Directive, as I said, and the 3 grounds of this directive which have led to litigation have been disability, age and sexual orientation. I already mentioned nothing on religion or belief yet, no cases on religion or belief. Just to say that I find that interesting and odd, given that the Court of Human Rights gets a lot of cases on religion, including cases dealing with employment. So you could say, well, the EU legislation only deals with discrimination in employment. But the Court of Human Rights has received many cases, a cluster of cases recently in the last couple of years on religious discrimination, dress in particular, dress codes, wearing a crucifix, headscarf cases, and so on. So it's interesting, the Court of Justice is not seen as a forum for some reason in which to bring these claims as yet by litigants. Okay, so disability discrimination. Well, there is a small cluster of case law on disability discrimination, more than in race, but still not a huge number. And one of the earliest, I think, was an important case, Coleman, where the court ruled that discrimination by association, that is, where somebody was discriminated against at work because she had a disabled child, was covered by the directive. I would consider that to be a progressive, inclusive kind of ruling because it went beyond the terms of the directive. So that's more in line with the approach the court used to take in sex and gender, kind of pushing the boundaries in a way of equality law. Then there have been a whole cluster of cases on the definition of disability, and I think these are interesting and kind of ambivalent. So the directive doesn't define disability, and so it's up to the court to kind of give flesh to that. And so in an early case, Chacon Navas, it said illness is not disability. So they're different. They're two different things. The directive doesn't cover illness. In a later case, Ring and Scuba-Berg, it said, well, illness can become a disability if, and this is the interesting definition, it can become a disability if it leads to a limitation which in interaction with various barriers may hinder the full and effective participation of the person concerned in professional life on an equal basis with other workers. So it's about a disability, illness can become a disability if it hinders your equal participation in working life with others, if it results from a limitation, physical, psychological, which is an impairment that hinders your full and effective participation in interaction with other barriers. So it's quite a broad interpretation, although it focuses on this labour market dimension. So the court has made the definition of disability for the purposes of the Framework Employment Directive labour market related already. It's included almost that in the definition of disability. So that's a narrowing factor in my view, but that's what it's done. So then in another case, FAO, it decided obesity is also, like illness, not covered as a disability, but just like illness, it can become a disability if it leads to an impairment which has the same effect of hindering equal participation in the workplace. So I think these cases are interesting. They're the court giving meaning to disability, somewhat cautiously, back to the market focus, the employment focus, and not really wanting to go beyond that. But I think one of the harshest cases, and I'd be interested to see whether some of the other commentators later who are talking about multiple discrimination and also about reproductive technologies would have any views on this, but the case of Z, as it's just the letter, an Irish case in which a woman who was born without a womb and therefore couldn't give birth to a child, had a child by surrogate. And she was able to, wanted to look after the child, wanted to take leave, and had she given birth to the child, she would have been covered by the EU Pregnancy and Maternity Directive, and she would have had a period of paid leave. She was not allowed a period of paid leave, and she couldn't take adoptive leave either because this was a child born by surrogate. So she wasn't covered by the sex discrimination law, by disability discrimination law, by the pregnancy directive. She was outside all of them in a way because she was covered a little bit by each of them. So it's a classic case, I think, although I'd be interested to hear more, of kind of multiple discrimination, leaving someone worse off, being in a position where, because of the intersection of a particular kind of disability with a particular kind of gender-specific problem, she was not able to get the period of paid maternity leave, but would either have to leave her job or not take any leave for the new baby. So she, the core question for disability was, is this not a disability, not having a womb, not being able to bear a child? And the court said no, because we've defined disability as something that hinders your participation in the workplace. This doesn't hinder your participation in the workplace. So even though you could say, but it hinders her ability to participate like others in the workplace, and that is taking leave when you have a baby for the first few months, the court rejected that. And I think one of the most interesting things about that case, and this touches on the comments that Professor Papadopoulou made in introducing me, and that is the court takes this extremely rejecting approach towards the UN Convention on the Rights of Persons with Disabilities, because of course the litigant pleaded that because infertility would be considered, I think, a disability under the UN Convention, and said, no, the UN Convention can't be invoked here. It's not directly effective, it's not clear and precise, it's programmatic. Now that's an incredibly strange ruling from my perspective, to say the Convention on the Rights of Persons with Disabilities is too programmatic to be invoked before the Court of Justice. The Convention on the Rights of Persons with Disabilities, if anyone reads it, is expressed in exactly the same language as the EU Anti-Discrimination Directives are. It's the same kind of prohibition, same kind of reasonable accommodation, direct and indirect discrimination, but there we go. It's international law and it's outside, cannot be invoked to question the interpretation of the directive. Okay, so an interesting factor there. Otherwise, I think on the couple of other cases on disability discrimination, Odar and Glatzel, the court is cautiously affirming of the rights of litigants. Here in Odar, it finds a calculation method for a pension worked to the disadvantage of people with disabilities. That was discriminatory. But in a case called Glatzel, somebody who was refused a driving license because the sight in one of his eyes didn't meet the EU required standards, even though when he used both eyes together he did meet the standard. The fact that each eye individually didn't meant he was refused a driving license. And he said this was discrimination on grounds of disability. The court said maybe, but it's justified on public safety grounds. So I think that's quite a strict ruling too, given a lot of work that's been done amongst the disability community about driving and sight problems in one eye and whether or not it is actually a public danger or not. So a modest amount of case law, about 7 cases altogether on disability, and the court's been kind of balanced, I think, veering between a progressive approach like in Coleman, Ring and Scuba Verba on reasonable accommodation, the cases on obesity and on disability pensions, and then more restrictive approaches in cases like Z and Glatzel, Z being the surrogacy case and Glatzel the driving license case. Maybe the 2 lines of narrowness I see are the insistence on labour market participation as part of the definition of disability, not just as the scope of the directive, but the definition of disability, and then not looking to international law to inform the EU law in this field. Sexual orientation then, how has the court been on this and what kind of case law has arisen? Well, here, interestingly, I think the court has been most consistently positive, in terms of finding always for the applicants. There have been, I think, 5 cases before the court, and all 5 the court found for the applicants. So there's a cluster of cases on same-sex partners, either just same-sex partners or in registered partnerships, being treated differently from married partners as far as workplace benefits are concerned. Cases like Maruko, Hay, Romer, Dittrich, Klinka, Muller. And in these cases, the court has said in each one, listen, if national law, for the purposes of national law, a registered partner or a same-sex partner is treated as equivalent to a married partner, then you can't discriminate in benefits. So it's kind of used national law as its justification, but said, listen, once there's some kind of equal treatment recognized, once your status is recognized as equal, then benefits have to be the same, workplace benefits, pensions, leave, other entitlements. You can't discriminate, say, but they're married, they get extra entitlements. Once registered partnerships or same-sex relationships are recognized as equal for the purposes of national law, then they have to be for private employers too in there, and for other parts of national law. And then maybe again, the case that's most notable, I think, or strongest in the area of sexual orientation, it's a little bit like the Ferren case in race about prejudiced employers. Ferren, remember, was we won't take immigrants because people don't like them in their houses. This one was about, interestingly, for those of you, I'm sure there's some people interested in soccer and football in the audience, for those of you interested in football, a football club in, I think it was Bulgaria, Associa Accept, where one of the leading shareholders in the club said, I'll never buy a gay player, we'll never have a homosexual player on this team. And the question was, well, is this statement by a shareholder of the club, does that amount to discrimination on the part of the club? And the court said, could do. He was a leading shareholder. It was obvious that he funded the club. He gave the direction to the club, and they generally followed. And the club did not distance itself from his statement. So the court said, okay, that gives rise to a clear presumption of discrimination on grounds of sexual orientation. So I think those are fairly robust cases in the field of sexual orientation so far. Maybe the most difficult cases haven't yet arisen. The Gráinne case that had arisen before these directives was one where the court was not willing to entertain same-sex equality, but now it seems to be going with the directive and taking its cue from that. So finally, the last cluster of cases, age discrimination. And here is where all the action has really been taking place. So as I've said, we had a small, maybe 5 cases on race, 7 cases on disability, around 5 cases on sexual orientation. There are maybe 24 cases, 20-odd cases on age discrimination, lots of case law. And here I think what you see is the court taking, moderate approach, I think is what I would say. Veering back and forth between just saying states can justify age discrimination and then saying, well, this discriminatory measure is just disproportionate. So there's a whole cluster of cases. And I think what's interesting about this case law is that it sheds light on the directive itself. The directive on age discrimination is highly qualified. Okay, so unlike some of the other directives, there are lots and lots and lots of justifications provided for age discrimination. So there's justification for direct age discrimination. This is very rare, by the way. Direct discrimination in EU law usually is hard to justify. There's 2 or 3 grounds of justification. One is the positive action. Well, some would say it's not a justification, but affirmative action or positive action. You can give advantages to one group who have been historically disadvantaged. I'm shortcutting here. That's one reason where you can have direct discrimination. Another is where there's an occupational requirement. It's a play, we need a woman to play the lead role, or we need a man, or we need a person of Indian origin, or whatever. There you can have direct discrimination on grounds of nationality, or direct discrimination on grounds of race or gender, or whatever. What the Framework Employment Directive does is to say in the field of age discrimination, there's lots of reasons you can use direct discrimination. National employment policy, vocational training policy, national security, health. We're used to this, right? Public policy, security and health is often used to justify discrimination in EU law. But usually it's hard to justify it. You've got to really show it was needed. You have to discriminate in order to achieve these aims. And I think in the field of age, there's a lot of latitude given to states and to private employers to discriminate. And so a lot of the case law is about that balance between discriminatory measures and whether they really are justified or not. Some cases lean in favour of the states. All the cases on compulsory retirement, except for, of course, Hungary, which was using compulsory retirement to fire judges who were thought to be unfavourable to the government. That was a case which was brought by the Commission, unusually. And the Commission brought a case under the Framework Employment Directive against Hungary for firing judges at age 62. Most of the cases about compulsory retirement are around 68, 65, and in those, the court usually said, that's fine, make way for younger workers, in principle it's okay, but in some cases it's been stricter, like in the case on, a case called Peterson on dentists. The court said, well, if, after they reach 68, they're not allowed practice on the public health insurance scheme. But they were allowed practice on private health insurance schemes, and the court said, well, then it can't be a matter of public health. If you're saying they can't because of public health, because they're not good anymore at 68, then why would you allow them practice in private if not on the public scheme? So that was disproportionate. You see that also with recruitment of policemen. Yes, it's okay to say youth is important for police to be trained and be still strong by the time they're trained, but to set an arbitrary age of 30 is disproportionate. Whereas for firemen, they were more willing to say, okay, for promoting firemen, maximum age was appropriate. So it's a nuanced case law. That's my shortcut summing up of the case law on age discrimination. There's a lot of it. The court is quite nuanced. It gives ground to the states in some cases. It's stricter in other cases. It uses a proportionality test in a fairly, I think, fair kind of way. But there's nothing striking in the cases. There's no, striking out for age discrimination. It's, if anything, slightly leans towards the employer and the state, the case law, in terms of permitting justification. Okay, so I'm going to wrap up my survey of, there's a lot of case law on age, which I won't take you through. I just want to wrap up the survey and say, what kind of conclusions would we draw from the picture that I've presented. Okay, this 10, 11 years of equality jurisprudence of the Court of Justice on race, age, disability, sexual orientation. Is the court retreating from the role it had previously? Is it playing a leading role? Well, let me address two separate issues. I want to separate out, because what I'd intended to talk about was just the court, but actually, as I did the work for this lecture, I thought there's also something very interesting going on about what cases are coming before the court, and I wonder what's behind that. So the volume of litigation that's come before the court. Clearly, age discrimination is the biggest group. And some of these cases have been brought by organizations, NGOs, and that is an interesting factor. Remember, I mentioned that these two directives have a chapter on procedural issues, and they encourage, in a way, states to empower NGOs, civil society, and equality bodies to support litigation. So you can see the effects of that, I think, in all the litigation that's arisen. There are some of these age discrimination cases brought by organizations, some by individuals, many with the support of organizations. The next largest group of cases is disability, then sexual orientation, then race, and finally religion, with no cases. So institutional litigants are important. These group litigants, these NGOs and equality bodies are clearly important in this field. And you would expect in a way that they are, because discrimination litigation is kind of public interest litigation usually. So obviously it also promotes the interests of individuals, but there are often public interest issues involved. But why has there been so much more litigation in the field of age discrimination than on other grounds? Well, I think one response is that age discrimination affects everyone, potentially everyone, old, young. Many of the cases, I didn't go through them in detail, but were about discrimination against young people, not taking into account work experience before the age of 20 and so on. Old and young, men and women, all races and so on. So there are many more potential litigants. But the second, I think, is that age discrimination is highly visible. It's one of the grounds which is probably, unlike the others, it's maybe I'm going out on a limb here, but it's less invidious. Most people accept that some age discrimination is fine, it's part of, employment policy, it's part of generational policy and so on, that there are times when people are too young to do things or too old to do things, or you want to make way for the middle generation. So age discrimination is highly visible. So most of the cases actually were about direct age discrimination, not indirect. So that's why, in a way, it's a field in which you can see the discrimination and you can work out whether it's invidious or not. So the cases really focus on careful appraisals of the facts. Was it disproportionate or not? Was it acceptable or not? It may also be that there are better resourced organizations helping people bring age discrimination cases, again, because more people are affected. It's not a minority community. It's not a marginalized community. It's everyone. And maybe, people who are older may be wealthier also in more of a position to bring cases. But why then so little litigation in the other fields? Well, in the case of sexual orientation and race, all of this is hypothesis, by the way, and I'd like to hear people's views on it. I'm hypothesizing. I am surprised by how little litigation there's been, especially in race, but maybe also in the field of sexual orientation. These are contentious issues where the world is changing, where there's lots going on, and the ECJ has not been used very much despite these new directives being in place. Well, sexual orientation and race, I think, these are the opposite to age discrimination. These are areas where overt discrimination, maybe less so with sexual orientation discrimination, where overt discrimination was accepted up till a few decades ago, but not really in race discrimination, where overt discrimination is known to be wrong. It goes on, but people hide it. So, for example, just to give you a case that didn't come before the ECJ, but in France, L'Oreal was the subject, the makeup cosmetics firm, the subject of an investigation by the equality body there. And turned out they had a systematic race discrimination policy where they only wanted white women to show off their cosmetics, to model for their cosmetics. And the way that was found out was by sending in blind applications using like Muslim names or ethnic surnames that would be obviously suggesting North African or some other kind of nationality. And it was found out that they were discriminating constantly there. They only wanted their cosmetics shown on Caucasian women. So that's an example where you get hidden but direct race discrimination. And the reason why maybe we don't have many cases is you don't see that kind of overt discrimination. But I still think it's curious that there hasn't been more litigation on indirect discrimination, you know, particularly cases involving the Roma, but also other kinds of minorities where there are issues of race and ethnic origin in place. So again, it might be resources, it might be that the Court of Justice is not seen as the best forum, the Court of Human Rights is still seen as the forum. I know that the Open Society Institute, which funds a lot of the race litigation, always uses the Court of Human Rights, the Strasbourg Court, even though they've complained that it's impossible to enforce those judgments. They haven't been able to get results in many of the big Roma cases where they won because they're not implemented domestically. You know, one would think that the European Union Court of Justice would be a better place to get enforcement, but as yet we don't see that happening. And I'd welcome any suggestions as to why. With disability, I think there is a sense that the disability community sees the Court of Justice as a good place to litigate, and that we will see more cases of this kind. There are a lot of issues on reasonable accommodation and so on. But it may be that, again, the reason why there is less litigation here is the groups are not well resourced either. So again, it's expensive to litigate and you don't get as many. The cases take place at local level, at employment tribunal level, and don't go up to the Court of Justice. You know, more generally with, I guess, sexual orientation, age, disability, we might say, well, it's the employment-related focus of the directive that means there hasn't been as much litigation. But I would think it would be very interesting to study, I don't know if anyone is looking for a research project, but something of that kind, to try to do a more rigorous study of why there's been case law in some areas and not others, or why there hasn't been litigation. You know, the why did the dog not bark in the night kind of question with regard to the two anti-discrimination directives. But then finally, just to come to the question of the court and how it has dealt with the grounds that have come before it. And my summing up in a way was that in the field of race, small number of references come to the court, but it's reluctant to take some of these cases on. You know, I think that we saw that in the Runovic-Varden case and in the Ferrin case, and other cases which are more justifiable where the court refused them, like Agafite and Servet, but still there's a sense of the court not wanting to take on race discrimination cases. The sexual orientation case is a small number, but the court is more affirmative of the litigation here in ruling in favour of the litigants. In the field of disability, it's a mixed picture, as we saw. Some cases which are strong and some cases which are narrowing or restrictive, like Z and Glatzel, and cases like Coleman and the obesity cases and so on being stronger. And then in age discrimination, a very nuanced case law on proportionate justification. So I think it would be fair to say that the court is not adopting a leadership role in the field of equality since these two directives were adopted. There have been one or two important cases, maybe Coleman and disability, Ferrin with race, Associa except for sexual orientation, but they're just sprinkled here and there, one or two cases. And most of the cases are cautious, careful. The court is following, not leading. So, you know, why might that be? What might the reasons be for the court to be more hesitant about these new grounds of equality and less creative and less, you know, insistent than it was with sex equality for decades, where it really was creating the law that later became enshrined in legislation, but the court made up most of that law. So, you know, one argument might just be that, you know, the newer grounds are a bit more contested than sex equality. So sexual orientation was one that took time, where it was a battle to achieve recognition of equality in that field and so on. You know, another might be with disability and race is that addressing inequality in these fields often requires expenditure, proactive measures, affirmative measures, reasonable accommodation, and kind of redressing historical disadvantage, and that the court is reluctant to get into those or to address those. There's also the race-nationality distinction drawn by the directive, and the court, you know, clearly doesn't prohibit discrimination on grounds of nationality against non-EU nationals. I think a second argument might be that the court is a bit more conscious of the legitimacy of the EU being in question, much more so in the last decade than before, and its own legitimacy too. And I say that about its own legitimacy because I think they're different, the EU's legitimacy and the court's legitimacy. But there is more focus on the court now than there used to be. It's not the invisible, quiet institution. You know, cases like Mangold led to a constitutional crisis in Germany, the case on age discrimination. The Court of Human Rights has been under major political fire in recent years, not just from the UK, but particularly there. But generally, why are these courts, who do they think they are, these European supranational courts telling us to rewrite our practices and laws and so on. So the Court of Justice may be more aware of itself as a court under scrutiny than before. And also the fact that this third directive was not adopted and is clearly politically unpopular, with Germany being in the lead of the states that don't want it adopted, that the court might be cautious. A third and kind of more prosaic reason might be, well, sometimes when the political sphere gets active, the legislative sphere takes over, the court doesn't need to be proactive. So there's lots of legislation now, very detailed legislation in these fields. The court doesn't have to take a vanguard role because there's, you know, they're not filling a gap. I don't know that that's so convincing to me, just because there was a lot of sex equality law in the 70s and 80s, but the court still did a lot with that legislation to promote it and push it. And the final suggestion, just to close with this, because it's probably on everyone's mind here in Greece, which is that the court is also conscious of the climate of austerity and conscious of the climate of crisis, economic crisis in Europe, and equality costs. Equality is expensive sometimes, not always, but it often is. It often does require distribution of resources, and that might be an additional factor dampening the court's enthusiasm for its vanguard role. So I have spoken for long enough. I will leave it at that and look forward to listening to the other commentators.
Thank you very much.
Oh. For us all organizers. Thanks for your
What is this? You have to show your present.
Okay.
Oh, that's beautiful. We have to see it.
This poems by Kavafi, a Greek poet, translated.
International Kavafis.
So you have a good start to learn Greek as well.
It's very nice. Μπράβο, πάρα πολύ ωραίο. Well, ladies and gentlemen, that was an extremely interesting speech by Professor Gráinne de Búrca, because she gave us in a lively way the most important cases of the European Court of Luxembourg on many different issues concerning discrimination or otherwise equality. Now, under my capacity as president of this table and as professor of international law, and talking to students, I would like you to remember and have always in mind that equality is a fundamental principle of international law and of national law. And it's not only mentioned in the Charter of the UN, but it's also incorporated in all international treaties protecting human rights. In fact, recently, a few years ago, we have a special protocol on equality adopted by the member states of the Council of Europe, is the 12th protocol to the European Convention on Human Rights, among others. So, according to my humble opinion, Professor, equality, apart of being a principle of international law, for me, is going to be, I hope, a jus cogens norm, because without equality, we don't have dignity. And without dignity, we're not human beings, because we're all born with dignity and we have equality. So these are notions that are very much connected with us since our beginning, since our being born. Before I giving the floor to the rest of the speakers, I would like to pose a question, having the right, because I was very alert recently about issues concerning disability, and I was very surprised positively that the European Union as a union is one of the few or the only international organization being a member state in the United Nations Convention on Equality. So I think you mentioned before that the court said something, oh, this is international law, we don't deal. But on the other hand, in the European Union, they adopted a regulation asking all member states immediately to ratify the UN Convention on the Rights of Disabled People. So I would like you to give us some more information about that. And now I'm going to give the floor to our next speaker, is Assistant Professor Despina Anagnostopoulou, which is responsible for Jean Monnet Chair at the University of Macedonia, and she's going to deal with age discrimination. Is a subject that Professor de Búrca mentioned also. You have 10 minutes, 15 minutes? Thank you very much.
Absolutely, 10 minutes for age discrimination. Well, age discrimination is a recent ground of discrimination, and it involves all of us. This is why there is so much case law of the European Court of Justice. First of all, let's see, what is ageism? We know feminism, we know racism, and now, voila, ageism and stereotypes. We are all victims of stereotypes. You know James Bond. Why is not Pierce Brosnan the actor who plays James Bond? Because he is the victim of a stereotype. James Bond can be young always, he can change hair, he can change faces, he can change the people that act this personality, but the stereotype is that it is a young, dynamic spy that falls from bridges. Therefore, in 1971, Professor Robert Neil Butler has defined ageism, which is based on stereotypes and institutional practices that establish them in the modern society. Which could be institutional practices? Of course, access to employment in a certain age, or mandatory retirement age. That is a very good institutional practice, and it may affect everybody at some point of his or her life. It will affect, for example, all professors when they retire mandatorily at 67 in Greece. So, older people are thought to be less productive, slow to learn new skills and adapt to technological and organizational change. They are unwilling to remain in the labor market, and so on. These are the stereotypes. However, there is a great heterogeneity of old age. The majority of the old people are fit, with full physical and mental capacities. And nobody has defined any age at which rights and duties are modified. So older people still have rights, the same fundamental rights as everybody, and young people also have rights, and they are not the James Dean style or the Playboy style. They can be very mature, they can be very responsible, and they can very well enter the market. After this small introduction, just to show you the importance of age discrimination, I would like to make just 2 remarks on the case law of the Court of Justice, taking into account the references that were made by Professor Gráinne de Búrca in the United Nations Conventions and the Supreme Court of Justice in the United States. The first observation is that it is said that there is no mention of age as ground of discrimination at the international level. Is this true, or is this a myth? And this is very important because the Court of Justice, in its Mangold case in 2004, which was submitted in 2004, it could not rely on the directive and on age discrimination on the directive provisions, but it has invoked the general principle of age discrimination, a principle that still holds today when it is necessary. It is a very strict weapon, a very good weapon for the European Court of Justice of the European Union, I mean. And it has been greatly criticized by the German courts in the case of Honeywell, as Professor de Búrca has mentioned, and also in the bibliography. Even Advocate General Sharpston has said, how could it be? There is no such age discrimination principle. The court has based it's the foundation of the general principle of age discrimination on the international instruments and on the constitutional traditions of the member states. And Sharpston says, why? There are no such covenants. Well, here we are. Indeed, many covenants, the general UN covenants and the European Convention of Human Rights, indeed, they do not include age discrimination as a ground of discrimination. So it is a questionable protection whether under other status age discrimination could be abolished. Well, indeed, the European Convention of Human Rights in Article 14 says that sex, race, color, language, and so on, and other status, no age. The same with the UN international covenants, the same almost reasons in both international covenants on civil and political rights and on economic, social, and cultural rights. However, these covenants make comparison and make reference, as well as the Universal Declaration of the United Nations, on juvenile offenders, on marriageable age, on protection of children, on protection of children from economic and social exploitation, and age limits for young people. So age is there, inherent. And then we have the ILO, which is the International Labour Office, and in 1958 has drafted the Convention number 111 on discrimination in employment and occupation. There is nothing. But later we will see that there are instruments that indeed talk about age discrimination. And who has given first this battle against age discrimination? Of course, the United States, who have thought that this should be abolished, and they have adopted the Age Discrimination Employment Act in 1967. It took us about 20 years, not 20, 40 years for us to implement a provision like this. And indeed, even today, it is not that strong as it is in the United States. In the United States, there is about 2,000 complaints in the Commission of Equal Opportunities. Of course, a few have the possibility of being thought that they are justified, but indeed there is a lot of work that is done, and there we have people over 40 years old that are protected, and only in bigger enterprises, 20 employees or more, even overseas. And there is no upper limit. There is no upper limit on 65 or 70 as in other jurisdictions. This US Act prohibits discrimination in hiring, promotions, wages, or termination of employment for older people. And what I would like you to see is that since 1986, it has prohibited mandatory retirement in most sectors, with phased elimination of mandatory retirement for tenured workers in 1993. So this is very important because in the European Union, as Professor de Búrca has told us, the Court of Justice has in most cases thought that you cannot you can indeed have a mandatory retirement age. And then in 1980, We have the first recommendations on older workers from the International Labour Office. We have the termination of employment. We have the International Convention on the Protection of Migrant Workers, which cannot be discriminated because of age in 1990. And we do have the European Social Charter, which protects the right of children and young persons from exploitation and the right of elderly people to social protection. So our first conclusion is that there is no express convention on the rights of older persons, which all the NGOs demand since 1999 at least. But since 1980, we do have some international instruments that protect people from age discrimination. And there you can see some actions from the United Nations in Madrid, in Geneva, talking about the older persons. Anyway, you know, age discrimination has started from even in 1984 with Marshall, and it was combined with age. But I will not go longer on this. My remarks are this. The first one is that there is indeed a general principle in the European Union law on age discrimination that is indisputable. If we search the international instruments, we will see, and there is a protection in the Constitution of Finland, for example. So even other national instruments could have protection because of age, especially in penal code for juvenile offenders or anybody else. And the second remark that I would like to conclude is why the court has so balanced, nuanced, but I would say broad way of justifying all these mandatory retirement age limits, just because there is the intergenerational structure, just because there is the policy of employment or the social policy, or just because to have the young people enter the market. So in the case of Georgiev, for example, the Bulgarian professor had to go with the mandatory age limit in 65, and have some contracts, fixed term contracts until 67, just because to have younger people having professorships. Well, I know what the court does is to have some economic analysis. That's how the other writers describe it, that it takes a balancing test, and it tries to balance the welfare systems of a country, and if it does not go beyond the margin of appreciation of the member states, just like it was done in the Commission versus Hungary case, the recent case, where the court said, well, you cannot change the retirement age limit, which people will have to be fired as judges or prosecutors from 68 or 70 to 62, because you have to take in account their legitimate expectations, and why you do that, just to have young judges. This is not intergenerational balancing. And there I think that it is in contrast with the United States Supreme Court case law in McKimmel, McKinney, Kimmel court, cases where the Supreme Court does allow people not to retire so easily. There are some arguments there that maybe the court will change its policy, and we have seen that in the Commission versus Hungary case, but we will see what will happen, because for the moment we are very much behind the other jurisdictions in the United States and in Australia, which has abolished the mandatory age retirement. Thank you very much.
We also thank Professor Anagnostopoulou for the very important information she gave us about age discrimination and for keeping the time limit. Now, as to the issue of getting a pension, well, ladies and gentlemen, because I just retired, according to the Constitution, professors have to retire at the age of 67, well, it was good. Not only because we have to leave the place for the younger people, but because working for almost 40 years is a long time. I don't know, maybe in the United States they can stay as long as they like, but, well, you are losing experience, but you gain new people, and which is very important. Now I will ask to come to the floor Mr. Sterios Kofinis, PhD administrative judge. So we have a judge among us who is going to talk about racial or ethnic profiling, a challenge for anti-discrimination policies. You have 10 minutes, please. Thank you very much.
Profiling in Greece, as well as in most of the European countries today, is a blind spot in the public debate on anti-discrimination. Even the term profiling seems to be missing from the anti-discrimination vocabulary, from the Greek anti-discrimination vocabulary, and there is no jurisprudence on the issue. However, profiling as a practice is not unheard of in the Greek or the European reality, far from that, in fact, so it is a rather interesting concept to examine. Let's start with the definition. The European Commission Against Racism and Intolerance defines racial profiling as the use by the police with no objective and reasonable justification of grounds such as race, color, language, religion, nationality, or national or ethnic origin in control, surveillance, or investigation activities. From this definition, it is not difficult to conclude that racial or ethnic profiling amounts to direct or indirect discrimination. However, it is a practice widely used by police forces around the world because it is considered an efficient way of policing, in the sense that the maximum hit rates may be achieved with a minimum allocation of police resources. The ongoing debate on the issue, however, has not attracted the same amount of attention at the continental legal orders as it has in the US or Great Britain, for example. The reason for that is mainly social. Profiling as a practice is based on the belief that some racial or ethnic groups with visible features that distinguish them from the rest of the population have a bigger tendency towards law-breaking. Blacks and Hispanics are thus considered an appropriate target of profiling policies in the US. On the contrary, in continental Europe, we have a long history of discrimination against Jews and Roma people, or other ethnic and religious minorities. However, these minorities, probably with the exception of the Roma in some cases, don't usually share visible features that distinguish them from the rest. So profiling on the basis of religious belief or ethnic identity didn't seem that important for policing purposes in Europe. This has dramatically changed in the course of the past 20-25 years because of the massive immigration flows toward Europe and the rise of the threat of Islamic terrorism. Race and ethnic background are the two most commonly used features for profiling suspects and have thus gathered most of the attention. It is easy to see why race was the main issue in the US, while ethnic background has attracted more attention in Europe. However, in the last 20 years or so, especially after the 9/11 era, ethnic profiling against Arabs is very intense in the US, and racial profiling against African immigrants in Europe is also very intense. So we can talk of racial-ethnic profiling as one issue. The above-mentioned definition also comprises grounds such as language, religion, and nationality, which are usually indicative of a different ethnic background. It is, however, interesting that gender is not mentioned at all in any definition of profiling, even though it is common ground that men get stopped and searched much more often than women. The use of the suspect ground may be the result of official policies based on specific guidelines, or of unofficial practices followed by police enforcement agents, or of internalized prejudices that help translate guidelines such as stop and search whomever looks suspicious to all Roma people are suspicious of petty theft, so they must be stopped and searched. Proving profiling, as well as dealing with it, largely depends on how it works in practice. It is easier to prove and tackle profiling based on official guidelines than that based on personal prejudice. The most famous example of an official profiling practice was the guidelines issued by the US Drug Enforcement Administration in 1984, according to which drug shipments were driven north from Florida by couriers that shared common characteristics, among which was the fact that they were black or Hispanic males. It is obvious that it is relatively easier to prove this practice and tackle it by just abolishing the guidelines. Profiling is usually linked to police random stop and search operations. This happens for two reasons mainly. First, a police search is the most intrusive and obvious state interference with a person's private sphere. It is the clearest expression of the state's legitimate use of physical force on persons for whom there are at the time no actual indications of law breaking. Secondly, racial and ethnic minorities are stereotypically linked in the public perception to certain types of crimes, drug dealing, thefts, or terrorism. It is, of course, not clear how these stereotypes are generated, whether there can be statistical proof of minorities' bigger tendency towards crime, or what are the reasons for this tendency, if there are any. It is thus true that racial or ethnic profiling has caught the public eye mainly because of police stop and search activities. There is, however, no reason we couldn't speak of profiling in the case of, let's say, investigations led by tax authorities, public health authorities, ticket inspectors, etc. On the other hand, in the context of police investigations concerning a crime already committed, the racial or ethnic features of the suspect may in general legitimately be part of his profile. In principle, civilians are under the obligation to put up with controls conducted by police officers, tax or ticket inspectors, etc. However, a stop and search procedure is usually a nuisance and may often prove to be a real burden for the person involved because of the time lost and possible insults to his dignity. What really makes it a discriminatory practice, though, is the fact that, in comparison to members of the majority, minority group members have to endure this kind of searches more often. The actual violation of one's dignity comes from the fact that he is perceived as more susceptible to law breaking than others on the grounds of his racial or ethnic identity. Apart from that, profiling works as a self-fulfilling prophecy. The more you conduct searches on a certain group of people, the more these searches result in arrests of members of this group for various crimes. That reinforces stereotypes about the criminality rates among members of minority groups, and stereotypes, in their turn, legitimize profiling. The prohibition of racial or ethnic discrimination is a well-established rule of international as well as national law. The European Court of Human Rights has reiterated in the case of Timišev versus Russia in 2005 that no difference in treatment, which is based exclusively or to a decisive extent on a person's ethnic origin, is capable of being objectively justified in a contemporary democratic society. However, this was one of the rare occasions that ethnic profiling has been brought before the courts in Europe, even though it is well known that profiling is common practice, especially in the field of combating illegal immigration. In one of the most interesting cases of litigation concerning profiling in Europe, the Spanish courts, including the Constitutional Court, rejected the claim of a black Spanish woman who was stopped and asked for her identity document by a police officer in a train station in Madrid. Nobody else on the train platform was asked for identity documents, and when her husband, who was white, asked why his wife was singled out, the police officer answered that I'm obligated to check the identity of persons who look like her because many of them are illegal immigrants. The case reached the UN Human Rights Committee of the International Covenant on Civil and Political Rights, which ruled that when the authorities carry out identity checks for public security or crime prevention purposes, in general, or to control illegal immigration, the physical or ethnic characteristics of the persons subjected thereto should not, by themselves, be deemed indicative of their possible illegal presence in the country, nor should they be carried out in such a way as to target only persons with specific physical or ethnic characteristics. Even though racial or ethnic profiling is in principle illegal, banning it altogether is in fact quite difficult. There are three main obstacles to overcome. Firstly, the lack of statistical data that will serve as proof of the profiling practices. Statistics on racial profiling are not abundant in the US either, but in Europe they are literally non-existent, mainly due to the strict interpretation of personal data protection legislation. Information, such as race or ethnic background, is considered to be sensitive personal data, which falls into the ambit of a high degree of protection. Even though there seems to be no insuperable obstacle to the processing of such data for statistical purposes, EU member states in general, and especially police authorities, seem reluctant to collect information on the race or ethnic background or religion of the people who are subjected to identity checks. Secondly, the authorities tend to overemphasize the importance of profiling for the purposes of crime prevention or control of illegal immigration. That brings the public benefit factor into play, and courts have a tendency to take this argument under serious consideration, even though the ECHR has ruled, as we have seen, that there can be no balancing in cases of racial or ethnic discrimination. Normally, this argument is outweighed by the negative impact of profiling on the members of the affected groups. However, there are cases where the public opinion, and presumably judges, take a different stance on the issue. After 9/11, for example, profiling against Arabs was widely accepted in the US as a legitimate means to address the fear of Islamic terrorism, whereas profiling against blacks is in principle not accepted when it comes to the war on drugs. The third obstacle is of a practical nature. In the US penal system, procedural rights of the defendant are very highly respected, hence proving that a stop and search was performed on the basis of racial or ethnic profiling could lead to the suppression of all evidence seized, drugs for example, and thus to the dismissal of the charges. This is one of the main reasons that profiling drew the attention of lawyers, legislators, and the public opinion in the first place. In Greece, on the other hand, as well as in most of the European legal orders, possible pretrial procedural errors, such as an illegal search by police officers, can be remedied in a following stage of the penal procedure. Thus, evidence, such as drugs, can virtually never be suppressed. This could be one of the reasons why profiling never became very popular among Greek jurists. However, profiling, though it is hard to prove and will not get any drug dealers acquitted, is still an issue that must be addressed by human rights advocates in Greece. It is well known that racial and ethnic profiling is routinely used in police identity checks or anti-illegal immigration operations, such as the so-called Xenios operation, and has a huge negative impact on members of the affected groups. There could be a two-step strategy to deal with the problem. First, the issue must be made widely known, and it should be realized that it constitutes illegal discrimination. Strategic litigation in the form of civil actions against the state for damages on behalf of victims of profiling could play a major part in this step. The second step should involve some sort of legislative initiative against the use of profiling as a practice, providing for the collection of relevant data and some sort of penalties for officers. But the key to achieving a long-term solution to the problem is reforming law enforcement policies, training and supervision in order to eventually address the problem of prejudice and stereotype-based policing. Thank you very much.
Thank you very much for this very interesting speech. Talking about statistical data, though, some countries, they are accused by committees. Let's say, for example, the Committee on the Rights of the Child, that we don't know how many are the Roma in this country, especially the children Roma, or other categories, which is not data protection. In other words, apart from what you said, which is very right, we have to do a lot of work on other fields. You all know Lina Papadopoulou. Well, she's behind this very successful conference with Mrs. Anagnostopoulou, and I ask her to take the floor and talk about access to medically assisted reproduction, techniques, and non-discrimination principle. How far can we go?
Thank you very much, Ms. Chairwoman. Well, seeking for new fields where we could possibly apply the non-discrimination principle and the equality principle, well, necessarily we touch upon different subjects here and topics. I would like to shortly address the issue of medically assisted reproduction techniques and whether here we can apply the non-discrimination principle. And of course the question, how far can we go? Can we even stop? First of all, I will not refer to any case law of the European Union Court of Justice, but rather I will seek to search a little bit on the case law of the Strasbourg Court, the European Court of Human Rights, whereas you know Article 14 of the Convention actually needs another fundamental right in order to be called to application. So the first question then, in order for us to make the non-discrimination principle of the European Convention on Human Rights applicable, is to ask whether the access to medically assisted reproduction techniques is actually a facet, a dimension of a fundamental right. So first of all, I would like to address the question, is there a fundamental right for somebody to reproduce herself or himself through such kind of techniques? And of course, when we talk about fundamental rights, we talk about something which we can invoke even against the legislator or the government. And of course, we can speak either on a positivist way, whether there is a right in the meaning that a court or a legislator has already recognized it, or we can even ask the question from a less positivist, rather moral point of view or an ethico-political point of view. Of course, we refer to a civil right. I mean, for the time being, I don't want to go into the question of concerning social rights, which means enhancement by the state itself, funding maybe the whole process. So I would like to stay on the freedom point of view as a civil right. And there, I think we can apply the principle of non-discrimination as long as we have to do with freedom, not a social right, which means maybe asking for funds, and there are, of course, other considerations, like the one Professor de Búrca already mentioned, like in a state in crisis, maybe less funds are available, and then maybe this could be an obstacle to acknowledge a social right. But let's restrict ourselves to the civil right. There, of course, we have two different aspects of the topic. One of it has to do with the methods themselves, the techniques. So I call them the object, okay, what we refer to, something like, for example, the cryopreservation, or in vitro fertilization, or surrogacy, an issue that we have heard of, etc. The other, I'm not going to speak about that much because I don't have so much time, but I would like rather to concentrate on the second dimension, which has to do with subjects. In other words, who has access to medically assisted reproduction techniques, and there whether I can apply the principle of non-discrimination if, for example, the legislator in my nation state gives this right to access to medically assisted reproduction, let's say only to heterosexual couples, or only to married couples, or only to women, single women, but not to single men, etc. So can I there apply this principle of equality and non-discrimination in order for the subject, for the person who is interested to use such a technique, to insist on actually the state allowing him or her to use such a technique? There, if I go back to both the Convention and the Charter of Rights, maybe I can find some legal basis where I could deduce this right from. And of course, concerning the Convention, we refer to Article 8, the right to respect for private and family life. And I'm still on the ground of questioning whether I could actually deduce from Article 8 a right for anybody to have access to medically assisted reproduction. We have some interesting cases from the European Court of Human Rights, from the Strasbourg Court. I would rather not talk about the other cases, but I would like rather to concentrate on the Dixon case. This is Dixon versus United Kingdom. And it has to do with a prisoner. Dixon was a prisoner. So he was convicted for a life sentence for murder. And during he was in prison, per emailing or writing, you know, like exchanging letters, I'm not sure whether in paper or through emails, but he met Lorraine. She was also convicted and she was also serving a prison sentence, but she was released before Dixon. Both were married after all, but as a matter of fact, Dixon had to spend more time in prison, and when he was expected to be released by prison, his wife would have been already 50 years old, which would make actually her pregnancy through a physical technique, you know, I mean sex, very difficult. So Mr. Dixon applied in order for the authorities to allow him to have access to medically assisted reproduction, exactly because both of them didn't have enough time for a physical way of having their own biological children. Actually, the British courts denied that application because they said that their relationship had not been tested in a normal environment of everyday life, because both did not give any guarantees for sufficient provision for material welfare of possible children to be born, and that these children would be without a father for an important part of their childhood. And for these reasons, they said, you cannot have access to MAR techniques. So the English courts did not allow him, and so they went to the European Court of Human Rights. In December 2007, the Grand Chamber of the European Court of Human Rights in Strasbourg concluded that the UK's policy had not striken a fair balance between the competing public and individual interests involved. They said actually, the judges in Strasbourg, that the requirement to prove that the circumstances of their case were exceptional placed in an inordinately high burden on the applicants. That was too much to be proven, in other words, from the side of the applicants. So the UK authority did not have the right to ask for something so much. And they also said, the judges in Strasbourg, that the inability to have a child was not or should not be an inevitable consequence of imprisonment given the availability of artificial insemination treatment. Why am I referring especially to this case? Because actually this case opens a big window, or maybe a door, Because as we know, in most countries, in all countries, using more techniques in order to reproduce oneself, one needs to have some medical reasons. It is a question whether these reasons cannot be only medical, but could be only social. In other words, whether medically assisted reproduction should also be available for people who do not have a medical infertility history, but also a social infertility, like the one that Dixon, our prisoner, had. And then, of course, this poses the question, what is medically assisted reproduction? What is artificial reproduction techniques? Are they a medical treatment, like you have to be sick in a way, like we heard in the case of Z, that actually that woman was not considered to be sick because there was nothing that prohibited her from exercising her duties at work, but she lacked a womb. But even if that wouldn't have to do with biological fact, but it may be, like in Dixon's case, with a social fact. Should we actually extend the right of somebody to have access to MAR technique? If we say that it is not a medical treatment, as I have implicated through the title of this short presentation, I think that we could go very far away. And as a matter of fact, my own opinion would be that this is not necessarily a bad thing, at least as long as we stay on the civil rights dimension of the things and not necessarily to the social right, which means funding from the state for some people to have access to medically assisted reproduction. Of course, I can already hear the counter-argument here that maybe this is in favor of rich people and at the expense of poor people. This is a valid argument indeed, but according to my opinion, we should not actually restrict freedom just because we cannot extend it through social means to other people as well. So actually my question, how far can we go, has to do with other categories that fall under the social infertility, let's call it like that. Like, for example, a husband and wife living apart for professional reasons, other than imprisonment, like let's say that the husband is a sailor, for example, or also, let's say, for homosexual couples who, I mean, from the very beginning, they don't have the equipment to reproduce themselves, or single women or even single men when it comes to surrogacy, for example. Myself, I'm not very sure that surrogacy should be allowed, but if it is allowed, then why not a single man, and why isn't it discrimination if you prohibit a single man to have access to surrogacy and you only give the opportunity to a married couple, for example? According to my opinion, this is a ground where the non-discrimination principle could be applied, because if you search for a good reason to exclude some of those categories from MAR techniques, where these MAR techniques are allowed for other people, then according to my opinion, I cannot find a good reason to do that. So the question, of course, is always whether this might be a technological determinism, in the meaning that, well, as long as we have artificial insemination, like the Strasbourg court said, then maybe this leads us to the answer of our questions, or whether any other moral considerations beyond the rational, maybe, or the technological reasoning may restrict our own decisions upon that. I am of the opinion that actually we cannot resist, and what we should actually make sure is the equal protection or the equal freedom for everybody, and not any short-sighted, maybe, moral considerations. Thank you very much.
That was really a very original issue. And taking this opportunity, I want to tell you that the European Court of Human Rights in Strasbourg has taken some very, very grave decisions, like, for example, permitting a homosexual couple of men having a child under the condition they were living a family life, or even transsexual, and other more, which lead us to the conclusion, and here I would like to disagree with Professor de Búrca, that the European Court of Human Rights has really taken broader decisions on many issues. Of course, we cannot compare it with the European Court of Luxembourg, which is limited to the implementation of European law. But if you take the extent and the broadening of the jurisprudence of the Court of Strasbourg, you are going to be really amazed. And now I'm going to give the floor to our last intervention, which is Dimitrios Goulas, PhD, adjunct lecturer of labor law at Democritus University. Oh, that's interesting. He's going to talk to us about age-related discrimination in EU law, and I hope he's going to tell us of a similar case of the European Court of Human Rights against England. Thank you very much. 10 minutes, please.
Thank you very much. My presentation addresses the issue of workplace discrimination against people with HIV and AIDS in European Union law. And of course, we all know that people with, living with HIV and AIDS suffer significant stigmatization and marginalization in various aspects of their personal and social life, and of course in the workplace. And unfortunately, a large part of these stereotypes are fueled by misconceptions or misinformation concerning the transmission of this particular virus and the etiology of the epidemic. Of course, the protection against discrimination is a universal human right and is protected by many international conventions and soft law instruments. And I have cherry-picked here some of them that particularly deal with disability and HIV. And at the European Union level, as Professor de Búrca has already superbly analyzed, the European Court of Justice has called non-discrimination a general principle of European Community law, and we have specific provisions concerning non-discrimination in both the Charter of the Fundamental Rights of the European Union and in the treaty. But in the Directive 2078, as we know and we have already heard, discrimination is prohibited on the basis of 4 specific grounds: religion, disability, age, and sexual orientation. And HIV is not included among these grounds of discrimination. And the Court of Justice of the European Union took the view that this list of characteristics cited in the treaty and in the directive is an exhaustive one, which means that the provisions of the directive cannot be extended to cover additional grounds of discrimination. So this leads us to the conclusion that, according to the Court of Justice, HIV or AIDS could not be considered as an autonomous or additional ground of discrimination. But HIV could well be considered as a disability, which is one of the 4 grounds of discrimination named in the treaty and in the directive. As Professor de Búrca has mentioned, the concept of disability is not defined in the text of the directive, but has been autonomously interpreted and developed by the Court of Justice in a case-by-case fashion. So the court, in its first decision on the matter, drew a distinction between sickness on the one hand and disability on the other hand, and defined disability in a very narrow and restrictive way, which put too much weight on the health condition of the person. And this definition has met with widespread criticism because it failed to embrace the social approach to disability, and it rather reflected the medical approach to disability. if we would like to take a closer look at these two models of understanding disability, the medical or individual approach focuses on the physiological or biological dysfunctions of the body as compared to those of the healthy or non-disabled body. This means that this approach understands disability as a personal problem of the individual or as a health problem of the body. On the other hand, the social approach, which has been discussed since as early as in the 1970s, and in the meanwhile has been mainstreamed into various decisions of tribunals around the world, emphasizes not the impairments, but the social relations and interactions which hinder the full and effective participation of the person in social and professional life. This means that the social approach to disability understands disability not as a result of the impairments, but as a result of environmental, attitudinal, or architectural barriers which hinder the full and effective participation of the person in the social and professional life. In this regard, of course, stereotypes and prejudice play a very important role, and it is obvious that according to this approach, the social approach, we have a much broader scope of protection because, for example, not only current disabilities are covered, but also past disabilities with continuing stigma, forecasted or alleged disabilities, asymptomatic diseases such as HIV, etc. Now, of course, a milestone in the history of the legal protection against disability-related discrimination has been the United Nations Convention on the Rights of Persons with Disabilities, which has openly embraced the social model of disability. And as Professor de Búrca has written, this has been the first human rights-related international treaty which has been negotiated, signed, and ratified by the European Union itself alongside its member states. So this means that legally it prevails over the EU directives. So the Court of Justice, in its next case on the matter in 2013, took the chance to fine-tune its case law with the medical model, with the social approach to disability, and with the United Nations Convention of Disability Convention, and it actually echoed the definition of disability employed in the UN Convention. And this revised, so to call it, definition has been used, has been reiterated ever since by the court in its following cases on the matter. But the court has not had the chance yet to answer the question whether HIV could amount to disability. But I think that in the light of the UN Disability Convention and the social approach to disability, this question should be answered in the affirmative. And indeed, in late 2013, the German Federal Labor Court ruled that HIV constitutes a disability within the meaning of the directive. Now, I would like to close this brief presentation with some remarks about Greece. Sadly enough, in Greece, we have had recently a series of unfortunate events concerning HIV-related discrimination, one of which has led to the decision of the European Court of Human Rights in the case of IB against Greece, which concerned the dismissal of a HIV-positive employee. But since then, we have had also some good news. For example, a provision in law regulating the labor inspectorate stated that HIV equals disability. The Greek National Commission for Human Rights, which is an advisory body to the Greek government, interpreted HIV as disability. And the Greek ombudsperson on 2 occasions held that the dismissal of a HIV-positive naval officer and the HIV testing of trainees are unlawful. Thank you very much.
Yes. Thank you very much. there was also one more case before the European Court of Human Rights against Great Britain when he was suffered from AIDS, and because he was a foreigner and an alien, and his visa had expired, he was in the hospital, and immediately the authorities asked him to leave the country, to go back to his country in Africa. So, after exhausting local remedies, he went against Great Britain to the European Court of Human Rights, and then he said, if I go back to Africa, I'm going to die earlier. And for that reason, the court did not permit England to take him out of the country. Our last speaker is Professor Christina Diligiani, very well known to all the law students of Aristotle. And Christina is going to do the concluding remarks, but she has chosen a very interesting subject, the notion of multiple discrimination in European and comparative law. Εδώ δεν έχει πιο πολύ φως.
It's okay.
Θα πάρεις, ναι, θα πάρεις αυτό το μεγάφωνο.
I will stay here. Sorry, but it's difficult for me. It's a, yes. Okay, I'm very good. Thank you very much. Okay, I'm okay. First of all, I would like to thank Professor de Búrca for her kindness to visit our law school, as well as to congratulate her for her excellent lecture. I would like also to warmly congratulate the other speakers of this meeting for their critical interventions. The issue I would like to present to you today is closely related to those interventions. It is a conceptual and theoretical approach of them. More particularly, it concerns the notion of multiple discrimination, which is clearly inherent either explicitly or implicitly in most cases previously exposed. The term multiple discrimination, as used in Europe, is a generic term which includes any type of discrimination based on more than one ground. Theory distinguishes two main forms of multiple discriminations. The first, which is often referred as additive discrimination, takes place when an individual is discriminated against on more than one grounds simultaneously, and discrimination on the one ground adds to the discrimination on another ground to create an additional burden. Second form of multiple discrimination is called intersectional discrimination and occurs when two or more grounds interact, resulting in discrimination. The grounds are inseparable, and discrimination takes place because of their combination that creates a unique experience for the victim. Minority women, for instance, may face discrimination not faced by minority men when their religion forces them to cover their hair. Additive discrimination may be dealt with on just one of the grounds involved. However, for the victims who are convinced of having been discriminated against one more than one ground, it will be unsatisfactory if the other grounds are not discussed. This problem became more complicated in case of intersectional discrimination, since the discrimination may remain invisible when looked through the lens of a single discrimination ground. In any case, however, common characteristics of the two types of discrimination are the difficulties the law to address them. For instance, discrimination litigation raised by the victims on the basis of several grounds have particular low success. The technical difficulty to address multiple discrimination lies foremost in the absence of a good comparator. For example, a Muslim woman who is denied a promotion cannot prove discrimination when her employer promotes usually women of European origin and mostly people that are only men. The separate or combined evidence of discrimination based on ethnic origin and sex cannot be proven. The scope of our intervention is to examine the nature of multiple discrimination, the power relations that lie behind them, as well as the tools of the legal opposition that modern non-discrimination law offers in order to address them, focusing mainly on EU law. The notion of multiple discrimination has its origin in the so-called Black feminist movement initiated in the United States. More specifically, the term multiple discrimination has been coined by the African-American lawyer Kimberly Crenshaw, who combined it with the social theory of intersectionality with a view to criticize the unidimensional perception of identity adopted by both liberal and radical feminist theory and American non-discrimination law. According to the Crenshaw, this practice is deplorable for two reasons. Firstly, because it disregards the complex nature of human identity, and secondly, because it perceives identity groups as homogeneous and essentialized entities with uniform interests and values without taking into account the power relations within those groups as well as the inequalities generated from these relations. In the United States, the courts initially refrained from accepting multiple discrimination claims. In the Gráinne case, for instance, they turned down a discrimination lawsuit raised by 5 black women dismissed by General Motors, alleging that the signatory system followed by their employer, as well as the policy of last hired and first fired provided by the collective agreement he had signed with the union, discriminated against them as black women indirectly. The court refused to recognize the existence of a separate category of black women protected as such under the Title VII of the Civil Rights Act. In the upcoming years, American courts have addressed intersectional discrimination with great reservation. Nevertheless, in the beginning of the 80s years, they loosened their stance. In the Jeffries versus Harris City Commission case, a black woman had it informed one day before applying for one of the 2 vacancies at the company she worked for, that the post had been given unofficially to one of her colored colleagues. The district court rejected the claim. In contrast, the 5th Federal Court of Appeal acknowledged that the treatment in question was an intersectional discrimination on the basis of gender and ethnicity. According to the court, the fact that the category of black women is not recognized as a group by the Title VII of the Civil Rights Act does not exclude it from the protective scope of this law, since such an exclusion would leave the practices of unequal treatment against black women without sanction. However, United States courts have been reluctant to proceed to a broader recognition of intersectionality, fearing that this theory could encourage minority groups to raise various claims before the courts. Moreover, this fear forced American courts to accept that multiple discrimination only occurs when 2 specific identity traits, sex and racial origin, interact. Yet, intersectional discrimination on the basis of 2 or more grounds has been recognized in countries such as Canada, that provides a strong protection of minority groups, both because it recognizes multicultural policies in its constitution and because its courts had given priority to substantial equality by interpreting Article 15 of the Canadian Charter of Rights and Freedoms, included in Constitution in the light of the principle of human dignity. Finally, as concerns Europe, it is worth mentioning that just like the equality law of the United States, EU equality law includes no explicit provision on multiple discrimination. However, contrary to the United States legal system, where the courts had difficulty to assigning the legislators' intent to combat multiple discrimination to Title 7 of the Civil Rights Act, European courts faced no such challenge. Firstly, because EU soft law expressly mentioned multiple discrimination in great number of non-binding texts. Secondly, because Articles 8 and 10 of the Treaty of the Functioning of the European Union mainstream both gender equality and the other grounds of discrimination provided by EU equality law. And thirdly, because recitals 14 and 3 to the Race and Framework Directives respectively make reference to women who have been victims of multiple discrimination. According to a theological interpretation laid down by legal theory, the fact that both the framework and the race directives mention sex in their preamble states that they have the intention to operate in combination with other EU provisions that prohibit discrimination on other grounds. However, although the European Court of Justice has been regularly addressing discrimination cases due to the concurrence of intersection or more grounds of discrimination for reasons that are difficult to explain this time, it never managed to adopt this interpretation. Things, however, have changed because the European Court of Justice has recently tried two discrimination cases, the victims of which had invoked more than one ground of discrimination before the national courts. In the first case, the applicant considered herself to be a victim of multiple discrimination due to the employer's conduct during the recruitment procedure. More particularly, Galina Meister, a 46-year-old system engineer of Russian origin, whose degree had been recognized in Germany, had applied twice for a job for experienced software developer at the company Speak Design, but her request was rejected on both occasions without ever having been invited for a job interview and without any explanation as to the reasons of the rejection. Meister claimed to have been discriminated against on the grounds of sex, age, and ethnic origin and brought a case before the German courts. The Federal Labor Court, hearing the case at last resort, referred to question to European Court of Justice for a preliminary ruling. In the context of EU law, the dispute fell under the scope of three directives: the recast Directive 2006-54 on sex discrimination, the Framework Directive 2078 prohibiting, among other, discrimination on the basis of age and handicap, and the Racial Discrimination Directive 2043 prohibiting discrimination on the basis of race and ethnic origin. Although this fact renders evident that the question at issue has to do with multiple discrimination, the Court has not scrutinized it since the preliminary question posed to it concerned the mechanism of the reversal of the burden of proof. It states, therefore, that a job applicant who plausibly claims to meet the requirements listed in the job advertisement and whose application had been rejected is not entitled to information indicating whether or not the employer engaged another applicant at the end of the recruitment process. However, it simultaneously mentioned that the refusal to grant an access to information may be one of the factors to take into account in the context of establishing facts from which it may be presumed that there has been direct or indirect discrimination. The Gallina-Meister case has been heavily debated. Although the identification of an appropriate comparator was not at issue, the Court has left room for the application of a contextual approach of this issue by stating that a refusal to provide such information could be one of the factors to consider in discrimination cases. The second ruling of the European Court of Justice on multiple discrimination is the case Oder versus Baxter. In this case, the Court of Luxembourg has examined, in the light of two reprehensible grounds, age and handicap, a regulation included in a social plan which had been signed by the company Baxter and the work council of the business. The regulation at issue provided a reduction of severance pay for workers over 54, simultaneously taking into account the possibility of an early retirement due to disability. Mr. Oder, an employee of Baxter, born in 1950 and severely disabled, had to receive, on the basis of the aforementioned regulation, a reduced severance pay according to his seniority. The reduced severance pay was calculated on the basis of the date he could first retire, day which would be sooner in case of a disability. The European Court of Justice first excluded a discrimination based on age by invoking the exception provided by Article 6 of Directive 2078. It detected, however, an indirect discrimination on the basis of disability. The Court has underlined that the indirect discrimination at issue has its origin on the more detrimental repercussion of the restrictive regulation of the compensation provided by the social plan in a specific subcategory of senior employees, that of physically challenged senior employees. According to the Court, the members of the above subcategory would be leave their job earlier than the older workers whose benefits have already been restricted and would face, moreover, increasing expenses because of the combination of their handicap and advanced age. The fact that in the case at issue, the plaintiff had invoked more than one grounds of discrimination permitted the Court to examine whether or not the combination of those grounds could generate an indirect discrimination. However, the Court did not examine the possibility of intersectional discrimination, since the National Court did not include this issue in the preliminary question it posed. The other ruling, nonetheless, demonstrates the various forms of opposition that EU non-discrimination law offers. Although the direct discrimination tools that seek to ensure the formal individualistic equality do not facilitate the establishment of multiple discrimination, non-discrimination law disposes additional conceptual and procedural tools that can deal more effectively with this complex form of discrimination. Tools, for example, aiming to promote substantial equalities such as indirect discrimination, moral and sexual harassment, the reversal of the burden of proof, class action, proactive measures, and positive discrimination are more efficient to tackle multiple discrimination, not only because they facilitate the proof of the latter, but also because they allow a more efficient treatment of the problems generating from its structural and institutional character. Thank you.
We thank also Professor Deligiani for her very fruitful remarks for multiple discrimination on a comparative base between the United States, Canada, and of course the case law of the European Union. Now the floor is open for you, and I propose the following because our guest speaker has an obligation and we have to be more or less finished by 8 o'clock. I propose to write down all the questions and then the panel will answer one after the other. Who has the floor? Nobody? So everything was so clear that nobody wants to interfere. Also, some of you can pose the question in Greek if you like. Okay? So I will give the floor to Anna Maria Consta, a member of the faculty of the Law Faculty of Aristotle University. Anna Maria, would you like, how are we going to do? Okay. You may say, first of all, your name. Now you are very well known, but then you can, if you like, you can address the question to one of the speakers of the panel. If not, in a general way.
Yes, thank you very much. Is it open? Thank you. Thank you, Professor De Búrca. It was a really interesting talk and all the interventions. Thank you very much. This is a very interesting topic that is of interest to many of our Erasmus students. In the audience, we have many Erasmus students of the Aristotle University of the School of Law and probably, I guess, from the University of Macedonia as well. These are topics debated in the context of courses that we teach, like international and European social law and also comparative human rights law that Professor Papadopoulou also teaches in the context of the Erasmus program. I would like to ask Professor De Búrca regarding, as I understood it, and correct me please if I understood correctly, regarding the grounds of discrimination like race and like religion. These are the least dealt with grounds by the European Court in Luxembourg. And you questioned, I think, yourself why, and you proposed some probable reasons, and I'm wondering, we know very well that race, ethnicity, religion, and nationality, they intersect. In a sense, they are interconnected. And we know very well that in the EU context, non-discrimination on grounds of nationality is reserved only to EU nationals and not to third country nationals. Isn't there a fear, this restraint by the court, isn't there a reason there behind it? Maybe I'm thinking that they are afraid to expand protection on race discrimination or on religious discrimination because this will, as a consequence, would have as a consequence to start protecting third country nationals, economic immigrants. You know, nowadays in Europe we have great problems with illegal immigration and with a humanitarian kind of crisis, actually, with people coming from other countries that die in the Mediterranean and in order to enter in hundreds, actually in thousands, in order to enter the EU territory. And I'm thinking that in a way the EU court does some sort of politics here. Yes, it's also the economic crisis, you're right, in a way equality costs, but wouldn't it cost even more if it's going to be expanded to third country nationals?
Thank you very much. Other question? Well, the speakers are very happy because that means they gave you all the information you wanted, that there is no lacune. Huh? So I will give the floor to our guest speaker, Professor Gráinne de Búrca, to answer the question and many other remarks. Oh, who wants? Παρακαλώ.
Okay. I would like to, first of all, thank you for your very interesting speeches. And everything sounds very nice in a level where it reaches utopia. However, we must understand that at many levels of society, we cannot reassure that all laws and all according to discrimination or persons with disabilities, that, for instance, for the age discrimination, we cannot make sure that this sort of discrimination is not avoided because, for instance, you can make an employer hire a certain percentage of women in his or her company, for instance. But I don't know, that's what I wanted to ask, if there's a legislation that has to do with the percentage of youth he must hire, or if there is a like a percentage that says that young people are more, let's say, productive. That may be a stereotype, but however, it may also be true. So you cannot make an employer follow laws that may be against the productivity of his own company. And moreover, I would like to ask why we state so much on the HIV, and I understand that it's a very, very serious disease, and I think that we talk so much about it, and we have a specific category in this lecture about it because it is related to, let's say, homosexual people, and that itself, categorizing it and talking especially about HIV, is discriminating it from other diseases. For instance, you can say that an employer cannot fire someone who has HIV, so he is protected. But can he fire someone that is in his first stages of Alzheimer? Let's say he may forget many things that are not very important, but why talk so much on HIV and not on other illnesses as well? Thank you.
Thank you very much, too. Maybe someone else remember here on this third row?
Concerns. First of all, I'm Eleftheria, a student, postgraduate student in Aristotle University. My question concerns racial discrimination as well. Historically speaking, is a ground of discrimination that it is unfortunately majorly common. It has given rise in the past to hideous actions and to political practices that are unacceptable from a point of view of on a humanitarian basis as well as on a basis of social justice. And it affects today as well the institutional structure of our society. So why the court is so prudent? And the same question applies when it comes to religious. Is it the abstract notion of culture as an object of protection by law? Or is it political considerations that make the court to be so prudent as to these questions. Thank you very much, and
thank you for your question too.
Speech.
Last appeal. No more questions now. I give the floor to Professor de Búrca, and then we will close.
Great, thank you. Although I think probably some of the questions on age and HIV discrimination were also directed at other members, so maybe they'd like to come back to that. So let me just briefly address the different questions that were asked. There was also, you had asked a question yourself, Madam Chairperson, about why would the court not want to invoke or have the Convention on the Rights of Persons with Disabilities at UN level invoked when the EU is itself a signatory, has ratified it, has adopted a regulation requiring states to. It's a very good question. And I think as our colleague explained, that it's not in every case that the court does not cite the Disabilities Convention, but it does it selectively when it wants to, and when the outcome will comport with what the court is already inclined to rule under the EU legislation. I think the court is very, very reluctant to have international law cited as a source of law in the EU where it might challenge EU law. And I think its own definition of disability for the purposes of the Z case was not going to take infertility and the absence of a womb and so on as a disability because it didn't affect the workplace, whereas it might do under the convention and under American disabilities legislation and others. So I think it's very selective, so it's a little bit cynical in that respect. The question on whether the reason for race and religion is the reluctance to decide cases in this is to do with nationality, and whether it's really about the worry about extending protection to third country nationals and immigration and fears about that. That would be an interesting idea, except I think the case law goes in the other direction, and I'll explain what I mean. So the cases in which the court has extended protection in the field of race, Ferrin was precisely about we don't want immigrants in our houses. So it was actually a discrimination against immigrants rather than discrimination on the basis of race identified as race. But I think because it wasn't, okay, the case of Servet, which I mentioned, which was an Albanian man asking for a social benefit in Italy, that was clearly excluded by the directive because as a third country national, states are allowed to exclude you from their social benefits if it's not required by EU law, and it wasn't. So whereas to say we don't take immigrants in our houses is racist in a way that isn't just about third country nationals are, they're entitled to be treated equally as human beings. They may not be entitled to all the social benefits that are granted on a discretionary basis by the court. So the Ferrin case would suggest the court is open to protecting migrants. Also the Meister case, which you mentioned, which was a Russian woman, not an EU national. Whereas the cases the court has been avoiding, like the Roma case, they're EU nationals. So I'm not sure that the reluctance lines up with immigrants. So the court is reluctant for some reasons I don't understand. It doesn't want to get in. I think it might be more to do with resources in the case of race, the amount of positive action needed to really redress some of the Roma issues in particular. But I'm not sure. The other question about, can you really force employers to do things against their economic interests and so on? Can you tell them you must take a certain percentage of women or a certain percentage of young people? I mean, there aren't any laws at present that require that. So what there is at EU level, at international level, following the Beijing International World Conference, was the idea of having a soft goal for states to aim for 40% as some kind of notional goal for gender equality in terms of political appointments, corporate appointments, the workplace and so on. So it's out there as a target, a kind of a naming and shaming target for states, but there is no legal obligation on employers to hire a certain number of women and so on. What they must do is look at everyone on their merits and not allow gender as a factor to exclude someone who otherwise is a good worker. And I think the same is true of all the grounds we're looking at: age, gender, HIV, and so on. What the law is trying to get at is prejudice, stereotypes like you can't work here because you've AIDS and we might catch it, or you can't work, whereas it's just not true. Some people who have AIDS may be in a position where, like someone who has severe Alzheimer's, and may be so disabled that they can't do the job, in which case there are other reasons than HIV why they wouldn't be employed. They can't do the job anymore. But many people who have HIV are perfectly well able to work, and it's prejudice, fear, and so on that leads employers to, or insurance companies or whoever, to discriminate against them. Similarly with gender, very often, similarly with age. If older people are, or excessive, it's not just discrimination against the old, it's discrimination against the young too, with age discrimination. They're inexperienced, they don't know how to do it, and so on. That might be true, but it might not. You can have very mature younger people very well able to do jobs, and you can have very wise older people very well able to do jobs. So discrimination law is trying to root out the prejudice and allow decisions to be made on the basis of who's good for the employer as well as the employment, rather than on the basis of assumptions about conditions or gender or anything else. Is that it? I think that's all the questions to me. Did anyone else want to?
Κυρία Αναγνωστοπούλου, έχει το λόγο.
For the young people and the older people, there are financial incentives, training programs, and also there are financial incentives for the employers. So there is a report of the European Commission on the Directive 2000/78 of what the member states do in order to help and motivate employers to hire, for example, young people or older people. If you understand what I mean. So there you can find that in Ireland, for example, there is a training program for the early school leavers. In Italy, there is the possibility for the employer to have 50% of the contributions of an older person, and so on. So each member state has its own policy. Thank you.
Yes, I think the main reason that there is so much interest in literature and jurisprudence concerning HIV is because people living with HIV are highly marginalized and stigmatized community. And of course that they are, as a community, more socially active against the discrimination, and they keep their stories in the public interest. Of course, a lot of diseases can fall within the notion of, or the definition of disability that was described before. And it is, of course, an interesting comparison can be made to, for example, hepatitis, which is, as a virus, very similar to HIV, infects much more people than HIV, and still there's no so much prejudice and stereotypes against people with hepatitis, but it could also well fall within the definition of disability within the meaning of the directive and the EU law. And the other thing that you mentioned about prejudice against homosexuals, you have a valid point, I think, and it coins with what we heard about multiple discrimination. It is very common that stereotypes against people with HIV sometimes conceal hostility against other vulnerable groups, such as homosexuals.
Well, ladies and gentlemen, we came to the end of this conference. I would like you to give a very warm applause to Professor Gráinne de Búrca, who came all the way from New York, no, from Spain. She has been in so many places. And also to Professor Papadopoulou and Professor Anagnostopoulou for organizing this very, very interesting. And to all the excellent speakers, of course. Thank you very much for being here. And I will close with this one. You know, Jean Monnet was the man who created, among others, the European Union. People were inspired, and they gave the name of Jean Monnet to the church. And now the church are working together. So they're making something even beautiful. Thank you for being with us. Thank you very much.